Hi everyone. Mistrial. Amber Heard is at it again with a supplemental brief and a new motion which was filed on Friday, continuing to seek a new trial because the wrong juror was impaneled. And yes, we are talking about juror number 15. New motion filed by Amber Heard. Wrong juror, due process, new trial. And then Depp's team has now responded. I'm a lawyer in New Jersey, New York, and PA, and I'm here to react to Amber's legal team's attempt to once again upset the apple cart. You know, there's an old saying that if at first you don't succeed, try again. Amber's team has really taken this to heart. They just feel like if they keep filing something, eventually something's going to stick. But more likely, they're trying to set up the items for appeal. There's some serious problems with what they're doing. But let's look at what the new paperwork from Friday says. It says that juror number 15 was not the individual summoned to jury duty on April 11th. Therefore, a mistrial should be declared and a new trial ordered. So this is the same refrain from the original motion papers. They're just supplementing their arguments. Now, for the first time in this filing from Friday, we get some more information about the juror and the jury process in Virginia. But as I think I mentioned in the last video I did on this, the way that this basically works in Virginia is that if you're one of the lawyers that's representing, in this case Amber Heard, you get a copy of the jury, the entire jury, everybody that's going to be coming in that is potentially going to end up on the jury panel. You get their name, address, age, etc. 3 days in advance, so that if you are aware of a problem with somebody, you can raise it during the voir dire process, And for those of you who aren't lawyers, who aren't familiar, when you come into court and you select a jury, you have like a little chart, and as people get called into the box, you can ask them questions to find out about their biases and prejudices. You can say, do you have any celebrities in your family? Do you have anyone that you know who's suffered from domestic abuse? Have you ever been involved in a lawsuit? Do you work for a newspaper? Do you have any opinions about defamation? You can go through this entire colloquy to find out what you're dealing with. And if there's a problem with their occupation or their age, as was the case here, or the credentials, whether they're properly a juror in this jurisdiction or whether maybe they've moved since the time that they submitted their address information for jury duty, all of that can be explored. And attorneys who are regularly handling trials will take the selection of the jury very seriously because they're the deciders of your client's fate, or as the recent Netflix series on the Lincoln Lawyer calls it, the Guardians of Guilt, or Gods of Guilt. So they they're the ones that decide the ultimate verdict. So you want to make sure that they're people that are fair and even-handed, and in this particular case, I personally don't think that the jury was in any way tainted, or that having somebody else sitting in the box, certainly from within the same family, was going to alter the result. But that's exactly what Amber Heard's team is saying. They're saying that her due process rights were violated because this person who actually sat on the jury was not the person that was called to jury duty. And so does this actually matter? We looked at the Virginia statutes, we looked at how jury duty works. It would only matter if there was some intent to seat the wrong person, if the person was a plant, if the person was biased, or if there was some other indicia that Amber Heard had her due process rights violated and this person was not an impartial juror, somebody who came in with an open mind, but somebody who had their mind made up beforehand. And yet, all the paperwork that's going back and forth, there's not one single fact or allegation or suggestion anywhere that the juror was partial to Johnny Dep. So we get the actual ages of these people. So the date of birth of the juror that was called was 1945. He would have been 77. And they indicate that the voter registration for both of these individuals has them living at the same address. So it's clearly a father-son, grandfather, grandson situation. And we didn't know that for a fact before, but that's what everyone was assuming was the case. And now we know it for a fact. So then the motion goes on, and we get into the battle of the footnotes. In this supplemental brief, which, by the way, Johnny Depp's team notes was filed out of time, which is a big no-no, they state, Mr. Depp would be incorrect in contending Ms. Heard somehow waived this argument by not raising it during voir dire. Well, that's exactly getting to the heart of the issue. Amber Heard had a chance to vet these jurors. Her lawyers had their information ahead of time. They could have questioned anything that seemed anomalous or that was out of place, and they didn't do so. So in the law, we call that a waiver. There's a time that's set aside for each step in the trial process where you have an opportunity to do something, and then if you fail to do it during that time, you're not heard to complain about it thereafter. Because there has to be some kind of finality to things. Things can't just go on forever. Okay. And then it says here in the footnote, the responsibility to ensure that the potential jurors participating in voir dire are the ones listed on the jury panel rests with those individuals and the court. So now we get into VA Code 8.01-353, which I want to take a second here and look that up again because I've commented on it before, but I mean, Amber Heard's team just murders the statute and just misreads it on so many different occasions that it's almost like beating a gong, and just like the dissonance of them not actually going, they quote things from a statute that don't reflect what the statute actually says. It's absolutely amazing. I mean, I rarely see something like this by practicing lawyers in our district, but here Amber Heard's lawyers seem to do it all the time, and it's really upsetting when lawyers do this. But it says here, all counsel of record in a case will receive a copy of the jury panel for the trial at least 3 full business days before the trial. So that means 3 days before trial, and if not before that. Bredenhoff and Rottenborn got all the information on the jurors, and it says what that information entails. It says such copy of the jury panel shall show the full name, age, address, occupation, and employer of each person on the panel. So they would have seen this age discrepancy if they looked or cared at the time, and they did not raise it. So they waived their right to do so. But then it goes on. The statute has some very important language here that is just completely ignored by Amber Heard's team. It says, any error in the information shown on such copy of the jury panel shall not be grounds for a mistrial or assignable as error on appeal, and the parties in the case shall be responsible for verifying the accuracy of such information. You see this part here? The parties in the case should be responsible for verifying the accuracy of the information. So, who's responsible? The parties, their lawyers. Elaine and Rottenborn had to raise this when the time, at the right time. They can't just wait until after there's a verdict. You see how this works? If you waited till the end and you didn't like the result, and then you could just complain about something that hadn't been a problem or hadn't been something that you cared about before, you could always find something that wasn't to your liking. But that doesn't give you the right to upset a jury verdict. It's not how this works. And the attempt by Amber Heard's team to rewrite this statute and misquote it and say that the court is responsible. The court was the one that did this bad thing and caused this problem, which is of such grave concern to the public and causes a denial of due process, is it's really rich. but also completely wrong, and not something that's likely to gain any traction. Um, so now going back to the slides here about the actual motion, Depp's team has finally responded, and they've made a lot of the arguments that I've been talking about. They responded today, July 11th, and we're going to take a look now at their response, which is short. It's like 3 pages, and it's exactly what you would think that they're going to say. If you're a lawyer or if you've been following the case closely, it's 100% what you'd expect. So let's go to that now. Okay, so now that we're back to this, we're going to close this one. Okay, here's the actual make this a little bit bigger so it looks okay. Yeah, that's good. Perfect. So they get into the damages argument that she made. Let's not get too deep in the weeds there. They get into the consistent verdicts. The First Amendment doesn't bar recovery. Consistency, actual malice, sufficient evidence to support a finding of defamation by innuendo, and then juror 15. So let's skip ahead here and let's get down to juror number 15 first, and then we'll go back and go over some of these other things that we talked about in one of our earlier videos on this topic. And they made all the arguments that we thought they were going to make, so there's no great revelations here. But this one, this is sort of incredible. So the court should not conduct an investigation in juror 15 because the defendant has waived the arguments and has failed to provide any evidence of unfair prejudice or due process violations. In layman's terms, they're saying that there was every opportunity by Amber Heard's team to bring this up when the jury was impaneled and voir dire was going on, and they chose not to do it. But more to the point, even though this did not happen, there was no problem with the juror because it was somebody that properly could sit as a juror. It was a part of the public in that jurisdictional area. So, in fact, in the same household as the person who was supposed to be called. And so there's no indication that there was any problem with this juror. If they had brought it up back when the jury was first impaneled and said this person should be disqualified, they wouldn't have been. They would have been okay. And things would have gone on, which is probably one of the reasons why they didn't do so. It says here, Ms. Heard waived her right to challenge the accuracy of the information listed in jury panel by failing to raise this objection contemporaneously. And then citing to some cases, but also to the rule, which I just talked about and had on the slides. It says that such an irregularity shall not be cause for somebody to be panel or juror or for setting aside a verdict or granting a new trial. So basically the exact thing that she's asking for, the relief that she's seeking, is specifically anticipated by the statute, and the statute drafters went about making it abundantly clear that that was not what this statute was for. It was a procedural device to explain how juries were going to be selected, not one that could be used substantively to upset a verdict or get a new trial, which is what they're trying to use it for. They go on to talk about different cases where even if the relationship between the juror and the witness were a sufficient reason for disqualifying the juror, defendant who knew of this relationship accepted him as a juror without objection. His objection to qualification came too late. So here again, the attempt to throw the entire trial into disarray and cause a mistrial over this now is way too late. And they look at the footnote and go, Amber's footnote is wrong. The parties have a statutory obligation, the parties do, to verify the accuracy of the information, and there won't be an error assigned if they don't do so. And here they even indicate that the list came out early, 5 days before the trial, not the 3 that's required. So they gave them an excess and abundance of time to get this right. And then something that we wouldn't have known had it not been for Johnny Depp's papers is that Amber Heard's team knew about the juror discrepancy but didn't raise it during the entire trial. I mean, imagine this, right? There's this big trial going on, and it's televised on national TV. And Amber Heard's team has this information, they know about it, and they just save it and don't do anything. Not only after the jury's impaneled, but then throughout the entire 6-week trial, while everything is getting, all the witnesses are called, all the witnesses testify, people are coming in from all different states, all over the country, all of this work, the judge and her staff and the court and the sheriff's officers and the commentators and the press and everybody and it is coming in, and the whole time they know about this thing and they don't say a peep. They keep their mouths completely shut the entire time, and then they wait and see what the final outcome is. They don't like it, and now they complain. Oh, this should have been dealt with. This is unacceptable, due process. Our rights were violated. But it's really too late, and there's no way anybody can take this seriously. And they point out she never cites a case or any other instance where a court overturned a verdict or issued a mistrial for a similar type of confusion where like the wrong juror is sat, but it's somebody who didn't have any, there's no problem with them. They say that the supplemental memo that we're covering here is untimely and should not be considered by the court because they filed it late to try to cut off Depp's time to respond and to catch them by surprise, but this was no surprise because Depp's team was prepared for it. And this is one of the things that we argue a lot in court. I just literally argued this today on a motion that we had on like a personal injury case that we're handling, where the attorney for the other side comes in and goes, they cite no facts that would give rise to their ability to get the relief they're requesting, and they say to the judge, well, judge, in discovery, when we explore this issue and investigate it, go on a fishing expedition, we might find something. We don't have anything now, but we might potentially find something. That's not the way that the law operates. What mere speculation, supposition, or unsupported conclusions are not evidentiary, don't entitle one to relief. But here, Johnny Depp's team is pointing out that mere suspicion or possible inferences cannot be allowed to overrule the orderly administration of justice, for otherwise there would be continued delays and many proper verdicts would be set aside. The importance of avoiding another trial, having a final adjudication, if the first trial was fair, is of paramount importance. And so they're pointing out that you can't go to the final extreme remedy of setting aside a jury verdict, which is a huge thing. It takes a lot of time to get to, and a fair trial that was properly conducted, because you suppose there could be an issue when you haven't actually identified what the issue is. That doesn't meet the standard. So going a little bit deeper here, we're going to just move through some of these other arguments that I addressed in the earlier video, which I think are pretty interesting. So, okay. On the issue of damages, the only inquiry here is whether the time frames for the damages were acceptable, and they just simply point to the testimony and show that the jury could have arrived at the numbers that they picked, like the $10 million verdict, from the testimony that in a 22-month period during the window that was allowed, Johnny Depp lost $10 million or more, because there was witness testimony that dealt with that. Mr. Wiggum testified they negotiated a deal for Depp to star in Pirates 6 for $22.5 million, and that Jerry Bruckheimer basically, who wanted Depp, said that it became clear that we have to go in a different direction after the 2018 op-ed. So, I mean, they could have come up with 20 million. And Spindler, the forensic accountant, put the number at 40.3 million. So, with those numbers being the typical amounts that Depp would receive, I mean, there's plenty of ways the jury could have come up with at least a $10 million amount for his losses. And then they go into a bunch of other legal stuff. But that point, I think, is clear. I mean, imagine we just focus on the $20 million from Pirate 6, right? And we say, okay, he would have had to pay tax on that money, and this is compensatory damages for his loss. The jury could have decided, because there was testimony about the taxes, they could have just said, we'll cut it in half and go with $10 million. Or they could have determined that Depp's substance abuse or lateness to the set or some other thing contributed to his loss, but the defamation clearly was like the nail in the coffin, and therefore they only gave half of what the total amount testified to was. But there's plenty of ways the jury could have reasonably arrived at that figure. There's nothing presumptively wrong about it, or that is something that no reasonable jury could find. All right, so the consistent verdicts, we talked a lot about whether the verdicts are irreconcilably inconsistent, and if there was a way the jury could have reached these verdicts. We looked at the verdict forms, and they're doing the same exact thing that I did in my video, and they're just putting it into verbiage here. But Johnny Depp's team, well, they don't go into the same level of detail, I think, in their brief as I did in my video. They find that exactly what I said, that there are multiple highly specific and detailed factual elements of Waldman's quote about the hoax, ambush, and setup that the jury could determine were false, while still concluding that the abuse allegations by Ms. Heard about Depp were also false and defamatory. For example, the jury could have determined that Ms. Heard lied about being abused, but that she and her friends did not spill a little wine and rough the place up in an attempt to make a false police report. In other words, exactly what I said, that they were going to argue that just because Waldman overstated this as being a hoax and an ambush when there could have been genuine concern on the night of the 911 call, and while it might not have been a setup, and he did that with reckless disregard for the truth, they can still think that she's lying about the abuse, and that those two things both were true. So that she was lying about the abuse, and that Waldman defamed her in making this outrageous and overly emphatic statement about her activities here in the instance of the 911 call night. So I think that those are very consistent. There's no question. The judge will have no problem saying there are multiple ways the jury could have come to that conclusion, and I'm not going to substitute my judgment for theirs. Now we get into the First Amendment issues, which I thought were interesting, but I don't think they have legs. So this is this whole innuendo, this Pendleton case, where Heard's team cited all like the leading landmark cases about First Amendment, and the higher standard applicable to public figures, where you have to actually name them and state information about them that's untrue, it's knowingly untrue, rather than just in your commentary getting into some items that cast them in a false light, because you're allowed to be satirical and critical and comment on public figures. It's part of your First Amendment rights. But there's nothing that says that a claim by defamation by implication, and the reason, this is in this case because she didn't say Johnny Depp's name in the article. and she's given the right, if she's commentating, right? If she's a commentator, she can say, "Oh, Johnny Depp has been misbehaving lately. He's been stumbling around on set," and she can, even there would be no stand-up comedy if you didn't have these First Amendment rights, right? Like, all they do is talk about public figures on the late shows and everything. This is like their whole shtick, right? But these are statements based upon her personal knowledge. These are things that she's putting out to the public as facts. So it's really not defamation by implication or innuendo. But they point out that the line is drawn at defamatory speech. The target of such defamatory innuendo as a public figure does not change the calculus. Especially true when the actual malice standard is involved, and where the defendant made the statement with knowledge of falsity or reckless disregard for the truth. Normally a commentator doesn't know the truth, like I said, but in this case it's her statements about her personal knowledge of her past history with him. So it's not protected the way a stand-up comedy act would be protected. Then they get into the republication of the tweet. And here, she tweeted her article out to her fan base. And so under the law, that qualifies as affirmatively reiterating the statement. You don't republish a website. Like, if I take a news story here, like, let's just take, Johnny Depp's attorneys call Amber Heard's post-trial motions for a mistrial frivolous. This is on CNN. We're going to get back to that. But if I retweet that, I'm not adopting or reiterating CNN's headline or the contents of their article. I'm not doing that. But I also didn't write the CNN article. If I'm the writer, if my name is Lauren Del Valle of CNN, and I tweet this on my personal thing, and I have defamatory statements in here that are knowingly false because I falsified them, then I'm affirmatively reiterating those statements, right? Even though republishing somebody else's content generally is not violative of the publication requirement for defamation. So once again, because Ms. Heard is dealing with her own personal past history and personal knowledge, we're in a different area than the law that Heard's team cites, and Depp and his lawyers artfully point this out. And then I like this part. That is not the case here, where Ms. Heard's Twitter followers and Twitter users in general are a different audience than readers of the Washington Post online. While Ms. Heard cites to some non-binding case law in other jurisdictions about hyperlinks, it does not present the defamatory contents that are of the audience, and thus is not a republication. And then it also talks about cases where the defamatory contents of the article are not presented. But here, the defamatory statement was the article's title, which was prominently displayed in the thumbnail. So that pretty much puts that to bed. Alright, then they get into actual malice and whether or not it was sufficiently stated. I think that we all can see from the evidence that the jury found that she was lying, and that she was trying to benefit her career at the expense of Johnny Depp's reputation, and that's why they found that there was actual malice, and there's no question about it. And that pretty much sums it up, guys. That's the motion. So let's look at what some other people are saying, and then we'll bring this in for a landing and put it to bed. Frivolous. Depp's attorneys call Amber Heard's post-trial motions frivolous. So for those of you who are not initiated into the legal field, a frivolous motion is one that is made to vex, harass or burden your adversary that isn't based on sufficient legal grounds, and you know that it's not based on sufficient legal grounds, but you file it anyway. And in instances where you're making frivolous filings with the court, when you do that, you run the risk that the court will so find that there was a frivolous filing, and then they will issue sanctions and award attorney's fees to the other lawyer or the other legal team, so that that party doesn't have to pay for the cost of fighting your meritless application. So I think this is interesting because I think we're getting to the point here. You know, judges give a lot of license to attorneys to zealously represent their clients, but we are getting to the point at this stage where Amber Heard's repeated second, third, fourth, fifth bites at the apple are getting to the point where a frivolous sanctions motion could be coming. Here's another article. Pictures of Johnny Dep and Amber Heard, juror number 15, wrong juror, born in 1970, not 1945. Citing excessiveness of the verdict, claiming due process violations. This article is by the Daily News. Okay, here's another one. Amber Heard says wrong juror in defamation trial. There's a Forbes article by Marissa Delato. Summarizing, it's already been summarized in Deadline and Insider about juror 15, about the age, about the claims of due process violation, and the remainder of the arguments we just went over. And Johnny Dep verdict thrown into chaos. Deadline. Good headline. Once new trial. Same stuff. All right. So, in conclusion, I guess, what can we say here? I think that a good quote to sort of summarize where we're at is that all things in life must eventually come to an end, even litigation. And this attempt to throw out the jury verdict and get a new trial and have the judge declare a mistrial is rapidly approaching the point where it's going to come to an end abruptly. And anything that happens beyond that is going to have to be in the appellate setting. And I think for everyone's sanity and mental health who's been following this, it's high time that we move on to other things. And so with that, wish everybody a good day. And I hope that this was helpful and interesting. And if, I've just, really started doing these commentary videos in the last couple weeks, I would really appreciate it if you would provide some comments. Let me know what you liked or what could be done better. What types of, if you're watching this and you got all the way this far, let me know what kind of things you'd like me to talk about in future commentary videos where, you've got a real lawyer who can analyze these things or give some color to what's going on to guide me so that I can make better content and serve the audience better. And anybody who takes the time to do that, I really appreciate it and look forward to building up a good channel that serves you guys and provides content people are interested in. Thank you so much.